re-recording of week 5 of environmental law. I had some technical issues and I apologise particularly to all of those that spent some time to join me for that live session that ultimately we had to abandon. So this week, in week 5, we're dealing with environmental legislation, and we're also dealing with the concept of ecologically sustainable development. Unsurprisingly, when we consider what we mean by that term, we will look at environmental legislation. And in Queensland, the two key pieces of legislation that we'll certainly look at tonight are the Environmental Protection Act and the Planning Act. At a federal level, we'll be looking at the Environment Protection and Biodiversity Conservation Act, and we'll refer to some international material as well, and of course some leading cases. As you view this session, ideally you'd be in front of a computer or a tablet and you'd have an opportunity to look at the material that I'm referring you to, so you can follow that and learn as you proceed. So first I'd invite you to look at the Planning Act, and you'll see in the Planning Act there is a reference to Schedule 2 and the environment, which says that the definition of environment for the purposes of the Planning Act is by reference to the Environmental Protection Act. In other words, if you go to Schedule 2 of the Planning Act, look at the definitions, the definition of environment says, see the Environmental Protection Act, Section 8. So that section 8 of the Environmental Protection Act, then covers what we mean by the environment, both from the perspective of environmental enforcement and management through the Environmental Protection Act, and planning regimes through the Planning Act and the various regulations. So it's a very broad and encompassing definition of the environment. So let's look at Section 8 of the Environmental Protection Act 1994. And it's an interesting definition of environment because it's certainly not what I had originally anticipated the definition of environment would be. It's much broader than you might expect. So you'll see that environment includes, and even then, it means that it could be beyond that which is stated in the legislation. It includes A, ecosystems and their constituent parts, including people and communities. That's one part. The second, in addition to that, is all natural and physical resources. Now that's probably what I thought would be the environment, but that's only one part of that which is included within the term environment as per the definition. The third is the qualities and characteristics of locations, places and areas, however large or small, that contribute to their biological diversity and integrity, intrinsic or attributed scientific value or interest, amenity, harmony, and sense of community. So again, now we're talking about things that wouldn't initially come to mind when we talk about the environment, because we're identifying now the importance of scientific value. And in environmental law, we have that mix of that which is legal and that which is scientific based. But also within the context and the definition of environment, we're dealing with things like that which is integral to amenity, harmony, and sense of community, obviously for people. So they're the three inclusive parts, and then there's a fourth, saying the social, economic, aesthetic, and cultural conditions affecting the matters in paragraphs A, B, and C, or are affected by those matters. So when we talk about the environment, it is important to consider the legislation, of course. And the legislation tells us that we must go beyond simply looking at ecosystems and natural and physical resources. We must, for want of a better term, consider the human element. The legislation says that when considering the environment, we must specifically consider the effect on people and communities, And in doing so, we consider the social, economic, aesthetic, and cultural conditions. So that means that in terms of cultural conditions, we must consider Indigenous cultures and that which is important in a general sense to all cultures that share the environment. So when you're answering a question in relation to an environmental law question, it is, I think, very wise to consider what we mean by the term environment, and some form of reference to Section 8 would be usually important. And when you answer the question, if you're considering it from an environmental perspective, keep going back to that definition and see if that which you're arguing for fits neatly within the definition. It might actually give you avenues to argue additional means that, or additional arguments that you hadn't considered. Now, if we flow on from what we mean by the environment, I guess the next question is, well, what is serious environmental harm? From this perspective, I'm looking at the enforcement regulatory provisions of the Environmental Protection Act 1994. Have a look at Section 17, which provides the definition of what we mean by serious environmental harm. And it says, other than environmental nuisance, which is separately defined within the same piece of legislation, serious environmental harm is environmental harm that fits into 4 categories. And it's one or more of these categories. So unlike the definition of environment in Section 8, which says this and that and another and another, here you'll see that the final word on each of the 4 headings is, well, 3 headings is all. So we've got 4 sections, subsections to Section 1, and it's this or that, or that, or that. So the first is that serious environmental harm is environmental harm that is irreversible or high impact or widespread. Or serious environmental harm is environmental harm caused to an area of high conservation value or an area of special significance, such as the Great Barrier Reef. Or environmental harm is serious environmental harm is environmental harm that causes actual or potential loss or damage to property of an amount that goes beyond the threshold amount. Or serious environmental harm is environmental harm that results in costs of more than the threshold amount being incurred to take appropriate action to prevent or minimise or rehabilitate or restore the environment to the condition it was before the harm was done. And in each of those cases, when we refer to the threshold amount, arbitrarily the legislation says $50,000 is the figure. Now that may be higher if prescribed by regulation, and if there is regulation, then go to the greater amount. So serious environmental harm can be established by reference to the cost associated with loss or damage or rehabilitation or prevention if it's more than $50,000 or greater by regulation. But in addition to that, or rather alternatively, serious environmental harm can be established by something that is simply irreversible or high impact or widespread, even if it's not possible to quantify the value of any loss or the value associated with taking appropriate preventative harm. And then there are certain areas where, if they're of high conservation value or special significance, irrespective of whether the harm is irreversible or high impact or widespread, or irrespective of how much it might cost to prevent that or rehabilitate, or how much damage it causes, if it's in an area that's of high conservation value or special significance, such as a reef, then it might even then still be environmental harm that is serious. So when you consider that which might be serious environmental harm, you need to consider it from a very wide perspective. And there are a number of ways that you can establish that some environmental harm is in fact serious. One of the key concepts that we're talking about today, and you'll see often in environmental law generally, is this concept of ecological sustainability. And from that, we have this concept of ecologically sustainable development. So what do we mean by ecological sustainability? Well, here I'm going to refer you back to the Planning Act, 2016, Queensland. Have a look at section 3 because it defines what we mean by ecological sustainability. And the Act says that ecological sustainability is a balance that integrates a number of things, 3 things. The first is protection of ecological processes and natural systems at a local, regional, state or wider level, and economic development and maintenance of cultural, economic, physical and social well-being of people and communities. So let's break that down. Ecological sustainability, firstly, relates to a balance that integrates a number of factors. So when we talk about ecological sustainability, we're talking about a balancing act, so to speak. And what do we mean? It integrates a number of things. Protection of ecological process. Now, you might have thought that that was it, that would have been or should be the definition of what we mean by ecological sustainability, protection of ecological processes and natural systems, but it's not. It goes beyond that, and we have to balance things. Ecological sustainability requires us to balance those natural processes, those ecological processes, against economic development and against cultural, economic, physical and social well-being of people. So the people side of the equation is sometimes overlooked when we consider what we mean by this general concept of balancing ecological sustainability. So I mentioned that from that definition of ecological sustainability, we can then consider what we mean by ecologically sustainable development. And given the topic is today about legislation that deals with the environment, unsurprisingly, legislation across jurisdictions now incorporates principles of ecologically sustainable development. Now, there's a key question here. And the question is, all right, if ecologically sustainable development and ecological sustainability requires us to consider a balance, who makes the decisions and how do they make these decisions? So the crucial questions really come down to how decision makers and the courts use the principles. Certainly, ecologically sustainable development principles appear in objects of legislation or of regulatory authorities when carrying out their functions. Let's look at a key example of where the concept of ecologically sustainable development is incorporated into legislation in Queensland. Planning Act 2016, Section 3. Section 3 deals with the purpose of the legislation. And I'd urge you to read that carefully and, where appropriate, to refer to that section when answering a question that relates to environmental law. So in this instance, subsection 1 says, the purpose of the Act, that is the Planning Act, is to establish an efficient effective, transparent, integrated, coordinated, and accountable system of land use planning, development assessment, and related matters that facilitate the achievement of ecological sustainability. So the Planning Act says we have to consider all of these things when assessing. And again, it refers to ecological sustainability in subsection 1. In subsection 2, it says what that means is a balance that integrates the protection of ecological process, economic development, and the maintenance of cultural, economic, physical, and social well-being. In other words, it's the balancing act that I mentioned earlier between those three items. Now, subsection 3 goes a little further and says, but for the purpose of considering that balancing act, you need to consider a few further things, and it breaks it down. So the first of the three elements, if you like, that we need to balance, which is protection of ecological process, is referred to in subsection 3A. And it says, protecting ecological process and natural system includes conserving, enhancing, or restoring life-supporting capacities of air, ecosystems, soil, and water for both present and future generations, and protecting biological diversity. So that's the first part. So when we're talking about ecological sustainability, we're talking of balancing three aspects. For want of a better term, A relates to ecological process and natural systems. Subsection 3A says, well, when you're looking at that, here is more specifically what we need to consider. And included in those considerations are a couple of principles that we derive from international law. One of them is the principle of intergenerational equity, and another is the principle relating to protection of biological diversity. Okay, so thank you for staying with me on this. These are important concepts, and they're important when you come to answering legal problems in relation to environmental law. So the second aspect of ecological sustainability, the second, if you like, limb of the Balancing Act, is economic development. Subsection 3B says when we talk about economic development, we should consider diverse, efficient, resilient, and strong economies, local, regional, and state economies that allow communities to meet their needs but do not compromise the ability of future generations to meet their needs. Once again, in the context of economic development, we're seeing this concept of intergenerational equity once again. And the third, which relates to cultural, economic, physical, and social well-being of people, is included in 3C of the Act. So, as I've mentioned a couple of times now, when you're considering answering a question, do look at these definitions, do look at the objects and the way in which and the purposes that are to be referred to. So from a practical perspective, when decision makers implement these principles of ecologically sustainable development in a practical sense, it is largely determined by reference to the specific wording in the legislation. Now, there is a key word within all of this that you need to consider. When a decision maker makes a decision that relates to environmental matters and ecological sustainability and ecological sustainable development, note that the ecologically sustainable development is simply a factor for decision makers to consider. And when you see that word consider, bear in mind that it's relatively easy for a decision maker to simply state that ecologically sustainable development considerations did feature in the decision-making process, even though there may not be obvious signs of implementation in a practical sense. But nevertheless, decision makers, courts and tribunals, for example, VCAT, must consider the examples or the principles of environmental sustainable development. And so what are some of the principles of environmentally sustainable development that we need to consider, or ecologically sustainable development rather, that we need to consider? Well, I've mentioned a couple already, but one that we keep coming back to is the precautionary principle. This is a principle that has filtered down through international law and means the precautionary principle basically says that it is a principle that's triggered by the threat of serious or irreversible damage to the environment where there exists a lack of scientific certainty as to the extent of that damage. So that's one consideration. Other considerations: public interest, intergenerational equity, conservation of biological diversity and ecological integrity, and improved valuation, pricing and incentive mechanisms. Now, as we've identified in environmental law, there are a number of key sources of the law and stakeholders, for want of a better term. So we have the international, the national, the state and the local government. We also have the states and territories vying, as it were, for their say and their input in decision making. A lot of the material comes from international sources, and that won't become part of our law until it's adopted in legislation. But there are controls as to national strategies for ecologically sustainable development. I will share the screen. I hope this doesn't upset the recording, but I'll attempt it. So on the screen now, you should see an extract from the Australian Government, Federal Government, Department of Environment and Energy website for the National Strategy for Ecologically Sustainable Development. This was prepared by the Steering Committee, endorsed by the Council of Australian Governments. And it's a very valuable resource for fleshing out what we mean by ecologically sustainable development and strategies that have been implemented with notes as to who has been affected by ecologically sustainable development and things of that nature. You'll also see that there's a reference to some of the wider concepts like biological diversity. And at the bottom, you'll see the appendices include the Intergovernmental Agreement on the Environment and the Rio Declaration on the Environment and Development. I'd urge you to look at that resource. And while I'm sharing, I'll go to the Intergovernmental Agreement on the Environment. Again, accessible through the Australian Government, Department of Environment and Energy. And you'll see that this was an agreement which was arrived at by consensus of the federal government, the states and territories in 1992. And historically, what led to this agreement was the High Court challenges where the Commonwealth government, I think, uniformly succeeded in defeating the states to, as it were, establish its legitimate power to make laws in relation to the environment, even though it didn't have officially, strictly, I'll reword that. It didn't have independently the power to do so under the Constitution. So do look at the Intergovernmental Agreement on the Environment. The reason that might be relevant from a practical perspective is that if you're answering a question on environmental law and you're concerned about the interplay between the state government legislation and the Commonwealth government legislation, leaving aside that we know, of course, that Commonwealth government legislation will override any state government legislation on the same topic. From a practical perspective, this intergovernmental agreement on the environment provides a working statement as to how the national approach to the environment is conducted in a realistic way. I'll stop the share now. So, the national strategy for ecologically sustainable development and the intergovernmental agreement on the environment, both of those from '92, establish ways and protocols between the states and the territories and the federal government. The national strategy provides a framework for policy and decision making and an important resource. I mentioned earlier the Rio Declaration. You should probably have that bookmarked. Go to the Rio Declaration and you'll see that it states 27 principles to guide the international community to achieve sustainable development. I'll highlight just a few of the important ones. Principle number 3 says that regard must be had to the environmental needs of future as well as present generations. That's principle 3, that's the principle relating to intergenerational equity. Principle 4 says that environment protection must be a legitimate part of development. And again, that's what's led to principles around ecologically sustainable development. Principle 15 deals directly with the precautionary principle, and principle 16 deals with the polluter pays principle. There may be others that catch your eye, but certainly when answering a legal question, you'd want to at least consider those declarations in the Rio Declaration. Also, when you're looking at the Intergovernmental Agreement on the Environment, I'd urge you to look at the definition in that document of what we mean by ecologically sustainable development. ESD is defined in that agreement as in the following way. Ecologically sustainable development requires the effective integration of economic and environmental considerations in decision-making processes. Ecologically sustainable development can be achieved through the implementation of the following principles and programs: the precautionary principle, intergenerational equity, conservation of biological diversity, and ecological integrity, and improved valuation pricing. And you would have noted I've referred to that earlier this afternoon. So again, when you're answering a question, keep these principles in mind. Keep in mind from where they were derived. Also consider the fact that these principles have now achieved statutory force through the legislation I've referred to today at a state level. The principles of ecologically sustainable development have also achieved statutory force at a federal level. Look at the Environment Protection and Biodiversity Conservation Act 1999, and in particular, look at Section 3A. Section 3A deals with the principles of ecologically sustainable development and says the following principles are principles of ecologically sustainable development. Unlike the state jurisdiction, there are 5 principles, and they are A, decision-making processes should effectively integrate both long-term and short-term economic, environmental, social and equitable considerations. So there we have in that first of the 5 principles an integration of long-term and short-term intergenerational equity, and also a blending of economic, environmental, and social and equitable considerations, which is ecological sustainability. Other principles of ecologically sustainable development at a federal level: B, if there are threats of serious or irreversible environmental damage, lack of full scientific certainty should not be used as a reason for postponing measures to prevent environmental degradation. Now, that is almost a restatement of the precautionary principle. So in Part A, you can see some direct follow-through from international agreements and the intergovernmental agreements and the national strategies in terms of intergenerational equity. And then in the second principle, and this is 3A of the EPBCA, you'll see a direct reference to the precautionary principle. C specifically refers to the principle of intergenerational equity. D refers to the principles of conservation of biological diversity and ecological integrity being fundamental considerations in decision makings, as the fourth principle of ecologically sustainable development referred to in section 3A of the EPBCA. And then the final one is improved valuation, pricing and incentive mechanisms should be promoted. So just think about each of those when you come to answer almost any question that relates to the practice and implementation of environmental law, because these really are guiding principles. And I'm sorry to be walking through it so slowly and deliberately, but it's too easy to gloss over, and yet it's too important, because these are the basic principles in answering the questions or mounting arguments. So if, for example, in an exam question, you're required to come up with some arguments in favour of or against a certain position or proposition, then it's always a useful exercise to go back to first principles and think about this from the perspective of ecological sustainability or ecological sustainable development. And then think about what are the elements, what are the principles, where do they derive, what do they mean, and now how can you use them in a practical sense. I mean, for example, the last principle in the federal legislation says that when we're talking about principles of ecologically sustainable development, improved valuation, pricing and incentive mechanisms should be promoted. So you'll need to keep an eye out for that. And if you see any reference to those mechanisms, then bear in mind how they fit into the overall picture. That might be particularly relevant, for example, if you're asked to provide advice on behalf of a regulatory authority. It may be that prosecution is not the best way to deal with an issue. It may be that through incentive mechanisms, a problem can be resolved and still be resolved in a way that is supporting ecologically sustainable development. So that's all that I'll mention about the federal level for the moment, and I'll go back to the state level. So let's go back to the Planning Act, and I would like you to look at sections 4 and 5 in more detail. Section 4 of the Planning Act 2016 Queensland provides for a system for achieving ecological sustainability. And it says the system to facilitate the achievement of ecological sustainability includes a number of things, and you'll see 11 of them listed. I won't read them in full, but I would ask that you read those carefully. And as you're doing it, read them actively, thinking about how can these be used in a practical sense, or how are they used in a practical sense when you're reading other material. Then go to the next section, section 5, that provides for advancing the purposes of the Act, or the purpose of the Act. And you'll see there's a direction here to the executive. So the Parliament is saying to the executive in subsection 1 of section 5, an entity that performs a function under this Act must perform the function in a way that advances the purpose of this Act. In other words, the starting point for consideration of a regulatory executive decision maker is, in making the decision, am I doing so in a way that performs the function and advances the purposes of the Act? Advancing of the purpose includes following ethical decision-making processes that take into account short-term and long-term environmental effects, apply the precautionary principle, and seek to provide for equity between present and future generations. So that's a starting point. If you're challenging a decision made by a regulator, ask yourself, is the regulator following ethical decision-making process, bearing in mind all of those extremely important environmental principles? But performance of a function under the Act requires more than just that. It does involve having opportunities for the community to be involved in making decisions, promoting sustainable use of resources, valuing, protecting and promoting Aboriginal and Torres Strait Islander knowledge, culture and tradition, conserving places of cultural heritage significance, providing for housing choice, encouraging investment, economic resilience and diversity, supplying infrastructure in an orderly way, applying amenity, conservation, energy use to the built environment that is cost effective and public benefit, and avoiding, where possible, adverse environmental effects of development, such as climate change or declining human health. It's interesting that that one, which you might have thought was the sole basis for applying the Act, is actually listed as number 11 on the list. I'm not sure that you could advance an argument that one is necessarily more than the other, but it is interesting that that reference to climate change comes in at the end there, but it's still there. So these provisions are important in a number of ways when dealing with environmental law issues. They may be relevant when you're dealing with a development proposal or a prosecution issue or some other purpose. Now, one of the things that I've mentioned many times already, and we've raised it a few times already this afternoon, is the precautionary principle. Adopting and implementing the precautionary principle is a substantial part of the ecologically sustainable development approach in practice. The trigger is the threat of serious or irreversible environmental damage. Now, whether there is a threat or not depends on scientific evaluation and evidence. Therefore, when you're considering the implementation of the precautionary principle, one of the first things to consider is the quality of the scientific evaluation or the scientific evidence. And essentially, from a practical perspective, the law treats a person as a credible expert witness if that person is an expert in the field of expertise and the opinion that's provided by that witness is based on fact. You might use that in arguing for or against a particular proposal. And it may be that if you're seeking to attack something which is stated as being promoted or being promoted by the scientific community, then you'd want to challenge, generally speaking, two things. Does this person have expertise in the field? And secondly, is the opinion provided based on facts? Now, full scientific certainty is an issue that must be considered when considering the precautionary principle, or more particular, lack of full scientific certainty. And a question arises, well, when do we reach a stage where we can say that there is such a lack of scientific certainty that it should not be used as a reason for postponing measures to prevent environmental degradation? The generally accepted scientific criteria for probability is 95% confidence level. That is in animal or human studies. In putting all this together, you might look at paragraph 4.65 of your text, which is, I think, 8.73 in the 9th edition. There's a reference here to the decision of Telstra Corporation against Hornsby Shire Council, which is 2006 NSWLEC 133 at 166 through to 178, judgment of Chief Justice Preston. And the definition is really helpful and says, the precautionary principle embraces a concept of proportionality. That is to say, measures should not go beyond what is appropriate and necessary in order to achieve the objectives in question. Where there is a choice between several appropriate measures, recourse should be had to the least onerous measure. A reasonable balance must be struck between the stringency of the precautionary measures, which may have associated financial, livelihood and opportunity costs, and the seriousness and the irreversibility of the potential threat. That's a really good quote, and it helps to put it all into a bit of balance and perspective. Now, a few examples of this in a practical sense. The first case is Adani Mining, Pty Ltd, against Land Services of Coast and Country, Inc., which is 2015 QLC 48. In that case, the Queensland Land Court distinguished between precautionary measures that were appropriate to deal with uncertain threats and preventative measures to control or regulate the relatively certain threat of serious or irreversible environmental damage. It's fair to say that in Queensland, both the Planning and Environment Court and the Land Court endorse a cautious or precautionary approach to avoid circumstances that might trigger a precautionary principle. An example is Telstra Corporation against Palm River Shire Council, 2001 QP ELR 350. And you can read more about that in the text around that same area that I've just quoted from. But bear in mind also that when you're looking at the case law, this is a fluid process. In other words, legislation may overturn decisions of courts. Therefore, you need to be aware of any potential in that regard. Here's an example: Fell against Can Recycling, South Australia, Pty Ltd, 2003 133 LGERA at 18. In that case, in that instance, the state government of South Australia overturned a decision to provide for refunds from recycled containers only where the containers were originally sold within the state. So Parliament does recognise ecologically sustainable development by enacting legislation, but also statutory instruments. Statutory instruments such as planning scheme policies, which acknowledge ecological sustainable developments. And governments recognise ESD by implementing the legislation through the practical application of these statutory instruments. Now, when courts review decisions of regulators, they'll often do so as a merits review, in which case the court also adopts the same principles. And therefore, courts recognise ecologically sustainable development by basing decisions on environmentally based concerns, such as the precautionary principle and the intergenerational equity principle. For example, in SHCAG Pty Ltd against the Minister for Planning and Infrastructure and Boral Cement, 2013 NSW-LEC 1032, the court upheld an appeal against a mine expansion development, and it did so by applying the precautionary principle in circumstances where there was a demonstrated lack of scientific certainty around the potentially harmful environmental impacts of the mine. In that case, the minister had approved the project. The court found the mine would have significant and unacceptable impacts, which led to a failure to satisfy the precautionary principle. And so that highlights the disparity between the recognition and acceptance of ecological sustainable development and principles associated with that at various levels of decision making. Sustainable development is all about good governance, and good governance means establishing principles of ecologically sustainable development in policies and laws that ensure that functions and policies and laws are exercised in a way as to promote and implement principles of ecologically sustainable development. And that's a paraphrasing Chief Justice Preston once again in Hub Action Group against the Minister for Planning, 2008, 161 LGERA at 136. So these are the principles, but how is good governance achieved in practice? I mentioned earlier that one of the practical ways of doing this is by establishing market-based instruments. And those market-based instruments include trading mechanisms, offsets, structural adjustments, and other economic incentives. So by encapsulating these market-based instruments into legislation, the government allows for a degree of accountability and transparency in relation to environmental law in practice. When it comes to the statutory interpretation aspect of environmental law, as always, read the words in the definition within context, and then read those words and that definition within the context of the Act entirely. And of course, that's the appropriate way to interpret legislation now. Be aware that words that are used in legislation sometimes do have a specific definition. Sometimes they're used, they're words that are scientific based. Many important concepts and words are not specifically defined, so it may be that you need to consider what courts have previously considered. For example, one of the cases that we'll come back to often during this unit is Booth and Bosworth. There's a few iterations of that case, but in particular, the reference at 2001, 114 FCR 39, where there was the question of what is meant by significant impact. And in the context of the EPBCA, in that case, the Federal Court held that the term meant something that is important, notable, or of consequence having regard to its context or intensity. So it is important, as best you can, to try to understand the approach that the court is likely to take. And the strict grammatical approach to interpretation may not necessarily give proper regard to the general purposes of the Act, which is why it's so important to go back to the purposes of the Act whenever you're considering a question of this type. So bear in mind some of the basic rules of statutory interpretation. Commonwealth laws override state laws. Later statutory provisions are intended to override earlier ones. An explicit statutory power must be intended to have priority over a general provision, and a construction that promotes the purpose or object underlying the legislation is the preferred approach. Also, just keep an eye out for that which is mandatory or discretionary. So statutory provisions that use the word must or shall suggest that the requirement is mandatory instead of the discretionary requirement generally associated with the use of the word may. All right, well, thank you very much for your patience. I really appreciate this. Sorry it's a little difficult just listening to a monologue, but I'll stop the recording now. And as I mentioned, the sessions in Christmas week, which in our case would be Christmas Eve, are cancelled, and I'll record another 2-camera session and upload that shortly. Thank you very much. All the best.